This program is presented by University of California Television. Like what you learn? Visit our website or follow us on Facebook and Twitter to keep up with the latest UCTV programs.
So just to start off, I guess I'm here to represent the obscenity side. I've been teaching a class on pornography as film and popular culture, as a genre and an industry, in the Film and Media Studies department here for 20 years. And because we're so close to the industry in the San Fernando Valley and North Hollywood, I'm able to invite to my class many of the leaders of the adult industry who come and very generously guest lecture in my class. And many of you are here and have done that and in the audience. I've lectured and published widely on pornography and on teaching pornography. I've been proffered as an expert witness in a federal obscenity trial and have advised the adult industry when I can on a variety of other issues. Most recently with my colleagues here, Murray Miller-Young from Feminist Studies and Celine Shimizu from Asian American Studies, along with author, pornographer, educator Tristan Taormino, we came out with the feminist porn book, The Politics of Producing Pleasure. It's the first collection to bring together writings by feminists in the adult industry with essays by feminist porn scholars.
I'm Peter Alalunas. I'm from the University of Michigan. I'm an adult film industry historian, and most of my research is in the era of home video, so roughly 1976 to 1986, which is the kind of nascent period of that industry. But my specific areas of interest are in the regulation of that industry, and not just in the sort of typical ways we think about that word, which would be like court cases and obscenity prosecutions and zoning laws, but also in sort of internal regulations of the industry, how the industry markets its content and structures itself economically and in its production and advertising practices. And so I think my stake in the panel is what I kind of like to think of as like a future historian's perspective. Like, how can we look at what's happening now from the perspective of someone like me who someday will sit on a panel and say, I'm an adult industry historian who looks primarily at 2014. So yeah, that's kind of my stake, is how obscenity regulation is changing, but how it also is very similar to what's already happened.
And Cynthia.
I'm Cynthia Chrism from the College of Staten Island, which is part of the City University of New York system. I'm interested in the cultural artifacts that are left in the wake of the kind of culture war, the debates, the policy negotiations that go on around indecency, and particularly currently writing about the bleep as a kind of workaround, right? That leaves us with, it's an observable instance of policy shaping content, the ubiquity of the bleep in not only unscripted, like reality programming, but in scripted programming at present.
My name is Jeffrey Douglas. I'm a criminal defense attorney in Santa Monica. I'm the chair of the board of the Industries Trade Association, the Free Speech Coalition. So obviously obscenity plays a rather significant role both on the policy and advocacy side of the Free Speech Coalition, and then I've also actually defended some obscenity cases, which are extraordinarily rare, even at the peak of obscenity case prosecution in the area of the time of Peter's study, still remarkably rare, but I've done a few. I also have the broader perspective of an extremist. I'm on the board of directors of the American Civil Liberties Union of Southern California, and so regulation of indecency is something that I am very passionate about as well. So I have a little bit from both sides.
I'm Diane Duke, and I am the CEO of the Free Speech Coalition, the industry's trade association. And I've been in this position about 8 years now, and came to Free Speech Coalition from Planned Parenthood, interestingly enough. And at a time when the Patriot Act was just coming to fruition under the Bush administration, and was really frustrated with what was happening around people's personal liberties. I'm thrilled to be in the position that I'm in, because we fight every single day against government's control of speech. And our industry is on the front line of protecting not only adult content, but everybody's rights. I find myself not just doing that in the United States, but we've gone to other countries. Jeffrey and I have lobbied ICANN. We've lobbied, for internet access. And so we concentrate on making sure that our producers can produce entertainment for the consumers, but also that the consumers have the right to see that. And so that plays a key part into the obscenity and indecency piece.
Hi, I'm Mark Kearns. I am the senior editor at Adult Video News, which is one of the two and the oldest trade magazines in the adult industry. I'm a journalist. At least that's what I figure I am, because that's what I do. I write. And I have been doing that for about 30 years. Before that, I was a court reporter, not newspaper, with the little stenographic thing, for 20 years. So I sort of had a little bit of a legal background, which I guess is why they always throw the legal stories to me. I love my job because let's see, I get to be so diverse. I attended, for instance, the Staliano obscenity trial. That was a lot of fun, and have attended several others. There's a fellow named Ira Isaacs who was prosecuted just in this area, and I attended his trial and actually got to see some of the movies that he was accused of selling. Oh my God, which is kind of interesting. But I write on a kind of a wide range of topics. One of my current interests is I was looking at the recent additions to the National Film Registry, and nice set of films ranging from pretty much the beginning of cinema up until the current day. And I noticed something a little peculiar, that there wasn't anything XXX rated in that list. So I'm about to start a campaign to get Deep Throat entered into the National Film Registry. But that's the sort of thing. If it's sexual, I get to write about it, and that's what I like to do. Plus, I get to take 3D pictures of naked people in porn sets.
Well, my name is Dan Linz. I'm here at the University of California, Santa Barbara in the Department of Communication. I represent what Des, in his keynote address, might have referred to as the obsession with evidence and measurement component of academia. My interest has always been in attempting to empirically verify the assumptions that are made by legal decision makers, particularly in the area of communication and law. And so when a legal decision maker tells me that exposure to a certain form of media will whet the appetite for child abuse or pedophilia, I begin to ask why. Who said? What evidence do you have for that kind of assertion? Or when we're involved, as currently is the case, and I hope this will be part of our discussion today, in what is the most recent, I think, federal government effort to engage in legal decision-making about pornography and obscenity, and that's something called Rule 2257, which has to do with the reporting of the age of actors in depictions, no matter what the depiction, really, including many amateur depictions that are now the number in the millions, if not hundreds of millions. The question becomes, for me, how big a problem is child pornography? Because it's the problem of child pornography that is used as the justification for this rule that there be a reporting requirement for now what is millions of producers of pornography in the United States, because there are millions of sites, individual sites and individuals that are engaging in the production of amateur pornography. How big is the problem of child pornography, empirically speaking? And then the question that I'm often asked is to quantify that, but then in service of the philosophical debate about is that problem big enough to justify the kinds of requirements that are put on speakers of sex-related materials in the form of these reporting requirements. To take one example, have done a variety of research in other areas of obscenity and other areas associated with the presence of sexually explicit communication businesses in the community. But I've always asked the question, who says? Mm-hmm. Is it really true? Can we bring the tools of social science to bear to examine the assumptions that are made? And unlike you, I hate my job.
We have to deal with those people.
Because no, then I'm asked to testify in court about what I think is the empirical reality of the situation, and I'm never listened to. Ultimately, judges come to the determination that some other, and I think that this was Dez's point, some other obscure piece of information can be used to justify their moral or political judgment, and that is what is invoked instead. So I find myself often in kind of a minority opinion and not feeling often very comfortable in court, and that's been the case for 20 years.
But we so appreciate the work that you do.
Well, that can't help me in any way. I appreciate you.
You have a fan base.
I quoted him.
So your frustration over the role that social science does not play.
Well, I share Dez, what I think
debates.
is Dez's really important point, which is that the only way media policy is made in the United States is with the patina of empirical research and having your facts in line. But I mean, as we know, facts are things that can be marshaled in a variety of ways and can demonstrate a variety of viewpoints. And I've never seen a fact unmolested, in such a way in the legal decision making involved in court that doesn't result in the selective application of that empirical information to justify, but essentially a moral judgment in this area.
Yeah. So I think you've already gone to the second part, which is what you think is the most compelling or vexing issue in obscenity and indecency regulation.
I have a real problem with religion. I have for years been writing these articles about free sexual speech, and you cannot write about that without running up against some religious organization who's decided that my freedom of sexual speech equals your depravity somehow. And not even so much mine, but anyone who produces any sort of media that has any sort of sexual content whatsoever they think is dangerous to them, and I can understand it, because my theory is that back in the old days, you see, if you had like gay people, then they weren't procreating, and so you couldn't get more members of the church. And I suppose if people are masturbating, you pretty much got the same thing. And so you got these very weird pronunciations about what's okay sexually with God and what isn't. And sadly, that still is what forms policy, too much policy, in this country today. And so I tend to write about that a lot. And the other problem that I write about a little bit is the amazing ignorance of at least the American population, if not the population of many countries, about essentially sex education. The problems are very basic and have very little to do with sexual speech itself. It has to do with people's reactions to sex as a subject and people's ignorance of sex as a subject, and in particular about porn, because that's the industry I write for.
I'm interested in, all of these topics are of interest to me, but what I've been focusing on recently is what's happening in the UK and what kinds of restrictions are being put on the internet. And so I think that there's a danger, especially with a country like the UK leading that type of restriction and those kinds of regulations. I think a lot of it goes back to what Dan was saying about so much subjectivity there and really ignoring the research that's out there.
Diane, do you want to just say briefly what the issue is around
Well, there are a couple things that are
policy?
happening. You know, their Prime Minister, Cameron, has decided to, I wrote this quote down because I just thought it was wonderful, work on the corroding influences of sexual content in the UK, and so and especially as it refers to the internet, and so they're looking at filtering at the ISP level. They were talking about regulating that if the ISPs did not voluntarily do that, and so most of them have. There have been a few holdouts that have said, if you want this kind of censorship, go to North Korea. Or find another ISP. I love that. And so the ISP filtering, there are some other restrictions where actually the consumers can be held criminally liable for having viewed, not even downloading, but viewed content, specific content that the government deems extreme. So those are just a couple of things that are happening in the UK, and people don't understand, people really don't realize that this is happening. And so, talking about what the over-filtering that's happening with the ISPs, you have to actually tell them you don't want the filter. So anybody who gets online now, joins an ISP, has this filter automatically now, and then they're going to grandfather it in for everybody else. So you will have to call your ISP and say, I want to watch porn. I want to see this. Put me on that list. And so we find that is troublesome, and so many levels. And then there's also an issue. They're pushing for age verification, which on the surface sounds kind of interesting and okay, of course. But if you dig a little bit deeper, there are some issues around free speech and around privacy that also concern us.
For vexation, I think the notion that you can punish, that a government can punish people, entities for breaking an undefined rule, that gets to the core of me. In many talks, including several here, I've pointed out the notion that you could be punished somehow for instance, compared to alcohol. You can have a rule saying no alcohol because you can define what alcohol is. But the notion that people could go to prison for drinking a bad drink is absurd. And yet, everyone seems to agree that only a tiny, tiny percentage of the enormous range of media could be classified as obscene. And yet, that 1/100th of 1%, 1,000th of 1% is A, undefinable in advance, but B, can result in absolute life-changing event. Everybody gets fired, business goes out of business, and people actually go to prison for years. And upon release from prison, they have they're registered sex offenders, which in the current iteration of being a registered sex offender limits the places that you live, how you can work. There's something so amazingly wrong with that, and inconsistent with not only the fundamental rules that date back truly hundreds of years in this country, but it also is just fundamentally incompatible with what everyone in their daily life thinks of as fair. A police officer shouldn't be able to fine you for saying, I just don't like how you're driving, with no further definition. And that is infinitely better than the actual rules are for obscenity. We get more outraged, ironically, with the rules of indecency, which suffer from the exact same problem, except that the worst thing that can happen to you is that an entity that can afford it was going to have to pay some money. That somehow or another is even more outrageous. But punishing anyone, even Fox TV, for an offense that is undefined, that is a source of great vexation. And then the other matter which we talked about, and I know we'll be talking about more, and which seems to me to be essential to this conference in every area we're talking about, is the far greater danger in terms of broad impact of private censorship versus government censorship. If an opportunity presents, I will talk about how remarkably ineffective government censorship actually is in terms of its own stated goals. It has broad impact in other areas. But private censorship, that is corporate censorship, that has a much broader chilling effect that does currently and will continue to impact consumers, creators, and their intervening distributors profoundly. And that is, of course, outside of this conference, something that's simply never even discussed or thought about.
I think that in terms of broadcast indecency, that some of the problems that will continue to loom are the difficulty of having a kind of democratically inclusive conversation about the subject matter when the data is so easily manipulated. There was reference earlier this morning to instances where public voice on media policy issues, 2 million letters, easily dismissed as partisan. There are other moments in which 500,000 letters, or 10,000 letters, or one complaint, right, can be treated as a pretty good indication of the mood of a nation, right? So there's an inequality, I think, given to various voices depending on how well the complaint, the letter, the movement at hand serves or disserves the powers that be at the moment. And I think that we also, face a real problem, like kind of back to the wall, with this idea of, broadcast community standards or community standards generally, and the idea that this somehow can be parsed regionally, that you could have Staten Island community standards or Santa Barbara community standards or Laramie, Wyoming community standards, when I think that any of us can acknowledge that within our own communities, on our own blocks, that there are a wide range of opinions about what is appropriate material for children, for example. So that idea of community standards, I think, is as understood and is used an unresolvable one, an unusable one that we simply can't persist with.
But I want to just take a minute and actually talk about what you were talking about, which is private censorship, because that's something that flying out here, escaping the winter hellscape in Michigan, I was thinking a lot about, which is Facebook. I just want to use that as an example. Because I think that there's a real tension right now about the role of social media in our culture. So here's a quote from a columnist recently who said, "In an era when Facebook has become the new town square, it's time that we demand a more democratic approach to what we can and cannot say and show to each other." But of course, Facebook isn't a town square. It's a private company that has no obligation at all to be a town square. And so I think we find these moments of misunderstanding and confusion all the time. So recently, for example, a very well-known photographer, Gregory Colbert, had an image removed from his account, and he said, Facebook has deprived me of my First Amendment rights and is trying to limit my freedom of expression. And then this quote, Facebook is not giving its community enough credit to trust that we know the difference between art and pornography, which really is sort of laughable because, frankly, no one ever in the history of the United States in the official legal capacity has ever been able to make that difference. So
I know it when I see it.
yeah, so I just, but he had like millions of people supporting this kind of rhetoric, and so the whole idea that Facebook is the new town square is like is a desire. It's a utopian desire, but unfortunately, it's just not a reality. And so, as that future historian, I'm extremely interested to watch over the next few years as Facebook and other forms of social media behind closed doors make these policies that are, it's beyond censorship. I mean, the door isn't even open. So yeah, there's a tension to be the town square with none of the actual rights and guarantees of a town square. So in the past, these sorts of debates would be fought in court, but there is no court for faith. It's only their boardroom. So yeah, that's something that I'm interested in. I think is like social media as a space in which these things play out.
Yeah, go ahead and take up.
If I may, I don't think that we've ever really had any town squares that aren't privately owned. I mean, town squares in the Midwest are covered malls. They're not the town squares, which are generally dead spaces, dead places. So there's always been this confusion about our rights of speech in commercially owned zones or commercially owned interpersonal exchange places. But I think there's also a confusion about our right, and you make the point that, well, at least you have the courts if it's a public domain and the government is trying to censor you. Well, what I always try to emphasize is that we have no right to sexually explicit speech. That right does not exist. It's been defined away, actually, by the Supreme Court. And the millions of depictions that you see, not only in the internet made by professionals, but made by your neighbors, are subject only to, are free only to the extent that there isn't an individual prosecutor willing to prosecute them. That is the only thing that's, and because it's costly, it's problematic politically, there's not a sense that the community will necessarily tolerate spending money for that, although these resurgences come up. And if there can be a technical fix in the form of what they're apparently doing in Great Britain, that would be much nicer, because then we avoid the rights discussion that we have in the United States about the public square. But make no mistake about it, we do not have a right to really sexually explicit speech. Because it's subject at any point to the whims of federal and local prosecutors.
And
Sorry, Mark.
Drawing on that for a second, because you talked about the 2257 trial earlier. Basically, 2257 is the federal record-keeping and labeling law, which requires when you make sexually explicit material for commercial purposes,
or not commercial
or
purposes.
not, yes.
Well, yes, or even not commercial purposes, and actually that was going to be part of my point later. You have to, first of all, keep IDs for every person who is in it, and you have to keep them in a certain way. You have to have them in a separate folder that does not, for instance, include also whether or not they've got an HIV test. You've got and you actually have to hire a custodian to keep all these records in the order the government wants you to keep them in, and a violation of that can put you in jail for 5 years. You also have to, if you're making this material, commercially at least, well, no, and not even commercially, but the people I deal with do it commercially, you have to have a quote-unquote 2257 notice right on the material itself, and on the box it comes in, and it has to identify, where the records that they require you to keep are kept, the name of the person who's keeping them. You can't have a pseudonym, you can't have a P.O. box. It's got to be a physical address and and an actual person. And so that's kind of crazy. But the point I was going to get to, which fortunately he also, is that although it's essentially the adult industry which is suing to get rid of this law, everybody should be suing to get rid of this law, for the simple reason that if you have ever sent a sexually explicit picture from your phone to somebody else's phone, or emailed a sexually explicit picture to anyone, you are supposed to follow these same rules. You are supposed to collect the ID from your partner and yourself and put it in a little folder and tell the FBI that you're going to be at the place where this folder is kept for 20 hours a week. And you have to be there 20 hours a week. And you have to label the photo or the video or whatever it is that says this is where the records are kept, this is who's keeping the records. And it's just crazy. But that part, I think you testified to it at the trial. Someone, I know, one of the witnesses testified to this. And that's the part that they're not telling you about, that this federal record keeping and labeling law doesn't only apply to the porn industry, it applies to every single person in the country who has ever taken, a picture that's sexy, that shows, genitalia in a what's the phrase? Lascivious exhibition of the genitals. I mean, this is crazy.
Which, by the way,
nobody knows what that means.
Need not be nude. If you can see the outline of the genitals, if the focus is on, they reformed the word genitals into the hip area. Now, again, none of us are saying that, if you took such a photograph, you will be prosecuted. But the idea that the government reserves the power to do that should be frightening to everyone.
And one of the things that I'm interested in is with obscenity prosecutions becoming more and more difficult because, what's the community standard in any given, that the jury's supposed to determine whether the work appeals to prurient interest or is patently offensive. So that is becoming increasingly difficult to prosecute materials for obscenity. So there are all these, what I call shadow policies, like the 2257 age record keeping laws, which also allow for warrantless entry.
Yes.
It should be said, warrantless entry to look at these records. But also the mandatory condom laws, these shadow policies when you can't use obscenity anymore.
Based on a shadow threat. It is impossible, and I've looked at this data, and I can't figure out how to understand it. It is nearly, I should say, impossible to understand child pornography and how much child pornography exists in the universe of communication. Yet, the idea, the specter, the possibility of child pornography can be used as a justification for all of these shadow policies that you're referring to. And there's no way to combat that and this is what's frustrating to me, from an empirical point of view. There's no way to demonstrate the null, that this doesn't exist, or even how small the problem is, or how large the problem is. It really becomes vexing.
And it's also, we have these cases where the law is enacted to fight a problem that doesn't exist.
Yeah.
Like the mandatory condom laws, to fight the problem of HIV in the industry and the risk of infecting the rest of the population of Los Angeles.
Yeah.
And the fact that there hasn't been a case of HIV infection within the industry on set since 2004. Okay, so it's this draconian set of regulations to counter a problem that doesn't exist.
As obscenity is concerned, it is hard to prosecute, but that doesn't stop them from bringing the prosecution forward. And the thing about that's very difficult is John Staliano was great because he was able to fund that. But how many companies have gone out of business because they think the average obscenity case is close to $1 million, Jeffrey? Would that
Now in excess.
Yeah, and so I mean, and our companies are small companies. The adult producers are small businesses. If you look at what the federal government considers a large business, we might have one company in all of our companies that meets that requirement. So think about that. They just drive people out of business. It doesn't matter if it's a good prosecution or not, just bringing it to trial or bringing it forward. And this is somebody's freedom that we're talking about, puts people out of business. And the only people who are required to watch pornography are the jurors. We are suing in LA County. We're suing LA County around Measure B. And this
We are supporting a lawsuit.
We're supporting, yes. We
just want to say what that is for people.
Measure B is the mandatory condom requirement, but as I said, I came from Planned Parenthood. The bloodborne pathogen regulations that they are requiring the industry to follow are the same ones that Planned Parenthood was required to follow. We're talking gloves, goggles, these elaborate bloodborne pathogen plans. So it's really more than just condoms. So there are a lot of things that skin contact, it's ridiculous. And when Constance was saying that no transmission has happened since 2004, that's nationwide. In LA County alone, 5 new cases of HIV are contracted or reported daily. That's daily. We're talking 10 years, no transmission onset in the adult industry. We have rigorous protocols that work. We work together as an industry to make sure that we provide the best possible, safest possible environment for our performers. So it's really, as you said, not only and I came from Planned Parenthood into an industry, and this was safe sex I've got purses made out of condoms. So, it's something that's very near and dear to my heart. And when I toured the clinic, the first clinic, AIM, that's a long story, but AHF, the organization that moved Measure B forward, pushed them out of business. When I toured that clinic, I was so impressed because it was a place that performers felt respected and were treated with respect, and they were given services that they want. We talked earlier about how money really does move it. We talked about our democracy, but this is where the campaign reform needs to happen as well, where the money is really leading our policy and our democracy is being purchased. So I think we all need to be involved in that.
And Cynthia wanted to say something, and Jeffrey?
Yeah, I was really interested in a case that involves, in television setting, the idea of shadow policy, which I think this is a really important topic, the shadow policy idea. And this was a case in Grand Rapids that started in the year 2000 on a public access channel. A guy named Timothy Huffman had a show with the wonderful title, Tim's Area of Control. Like that was the name of his show. And after 60-odd episodes of this show, in one he exposed his penis as part of a comedy sketch. And a casual viewer. Now, remembering that public access channels have minuscule audiences, that a casual viewer, someone flipping channels, runs across just at the moment that this particular 3-minute sketch is on the air, and discovers that complaining to the station isn't going to get anywhere, right? Because this is an unregulated area. And apparently casually mentioned to a friend in the district's attorney's, who worked in the district's attorney's office, that she was offended by this material. And Huffman ended up being arrested for indecent exposure and convicted. And the conviction stood through a series of appeals. And the court documents are really kind of hilarious if it wasn't, it would be hilarious if it wasn't, so important, I think, that the judges on the Court of Appeals said that they were pretty sure that seeing this material on the television screen was potentially more traumatizing than an exposure in real life, right? Why? Because it was sustained for a longer period of time, 3 minutes, than you would encounter on like a city bus or a street corner. And it was probably so much bigger on the screen than, if it was someone like across the way in a public park, right? But I think that the ruling forgot that TV has an off button, right? The remote control is right there, and real life doesn't. So that was a case where, a kind of shadow policy, a circumvention of lack of regulation in public access in terms of indecency or obscenity, those ill-defined categories. The Grand Rapids District Attorney's Office found a workaround, and the guy was sentenced, violated his probation, so did actually end up serving a year on this particular charge. And it's a case where, well, like you said, Jeffrey, just because there's a law doesn't mean it's going to be used in a particular way. This was a case where there was a law that had never, in any United States jurisdiction, an indecent exposure law, been applied to a representation, to a screen experience. And it doesn't mean that there have been a lot of copycat prosecutions, or that it's likely that there will be, but there could be, right? And I think that it was a case, a kind of surprising case in this particular area. Do we need to watch for more of these? I don't expect a tsunami of these kinds of prosecutions, but the possibility.
One is enough.
And one is enough, and there are other ways, right? Grand Rapids, public access channel funding in Michigan tanked precipitously after this incident. A similar thing, without the intervening, legal intervention, happened in Washington State. A public access show that was there were concerns about obscenity, and couldn't figure out any way around it except for massive budget cuts. So again, that's another workaround.
Well, I think that we were talking earlier about the need for media literacy, and I think that in Des's reply, he really made the case for, we need media policy literacy, because people do not understand many of the issues that you've been saying, because not only do we not understand media policy making and feel we have no hand in it, but we're also just ignorant about it. And this, of course, and one of the reasons why we're ignorant about it, for example, with indecency and obscenity, you do not know, when you as the creator are making that product, whether someone is going to find it to be indecent, or obscene, because again, it's just completely arbitrary and capricious and vague about, what it is that you are not supposed to do.
And whose complaint counts.
And whose complaint counts.
Well,
Again, if you walk into a bank and hand a teller a note that says, "Give me all your money or I'm going to shoot you," nobody's going to mistake that for anything but a bank robbery, okay? But I could make a sexually explicit movie today. It could be sold tomorrow. It could stay on the shelf for 10 years. And then some cop walks into the store, takes a look at the box and says, I think that looks a little weird to me. Takes it back to the station or the district attorney. They look at it, and suddenly you've got an obscenity prosecution when for 10 years people were buying this movie, they were enjoying it.
The impact of these random lightning strikes, and again, it is there. Even before the internet, there were millions of transactions a year of traditional, commercial, sexually explicit, X-rated, whatever you want to call it, transactions that were occurring in rental stores, in purchases, and mail order. Scores of millions every year. And at the absolute maximum number of obscenity prosecutions in the United States, at every level combined, it never exceeded more than 100. And that was in a very, very short period at the end of the Reagan administration, beginning of the first Bush administration. And the people that were behind it had very grandiose visions that these prosecutions were going to reshape the content of sexually explicit material that would be available, or, when they were being really grandiose, substantially diminish the amount of material that was being consumed in the United States, and they believed this literally religiously. It failed in every way you can imagine. That is, they took out, in '87, they took out the existing mail order structure. Virtually every adult mail order business in the United States was put out of business, except Adam and Eve. And the
Which
principles,
had the money to fight it.
right. and the principals imprisoned, and the companies out of business. And consumers never noticed for a minute because the demand was unaffected by it. And so all of the companies that had the content, had the videotapes, the distributors, the manufacturers, opened up mail order business. So in that regard, it's a failure. It's always been a failure. The next set of big obscenity prosecutions focused on anal sex because somebody in the government really liked or not anal sex. And it did not have much impact on the content, again, even though those prosecutions were largely successful. But what it does succeed in doing is distorting the distribution of the material. Why is it that Sony does not distribute or create X-rated material? It was because if there's a 1 in a trillion chance that they could be prosecuted for it, why in the world would they do it? And that means that the adult industry becomes a separate part of entertainment, which is entirely artificial. Doesn't make any sense, right? The non-adult entertainment industry, at least a significant portion, wants to put in a lot of sex because people like looking at pretty people having sex. But in order to allow themselves to be safe from prosecutions, or the threat of prosecution rather, they not only have to not show a penis, but they have to define themselves as not being the adult industry. So there are all of these pressures to isolate the adult industry. And as a consequence of it, you do affect content. You marginalize. If the barrier between adult and non-adult were actually fully permeable, the quality of sexually explicit content would be greater. It's not that there wouldn't be trash, because all you have to do is turn on television. You know that Hollywood's going to make, 99% of popular culture is trash. But it limits the ability of people who aspire for more to create and distribute it, because the distribution channels are narrowed. The primary barrier of distribution is not the government, it's the credit card companies, and if not now, it will be, these massive telecommunication entities. You should have been able to get porn on your phone almost a decade before you could, certainly 5 years before it was available on your phone here in the United States. It was available all through Europe, because the telecommunications companies simply said no. And of course, their guidelines were as meaningless and arbitrary as they possibly could be, because there is no distinction. There is no difference between art and pornography. There's an arbitrary legal distinction between art and obscenity, but there is no definition between art and pornography. In any case, they had all these artificial barriers, and the impact on commerce and content is overwhelming. And as we allow the conduits to control and define content, then having a religious fanatic in the Justice Department is not going to have an incredibly tiny fraction of impact as it will when there are these artificial barriers.
Having attended back-to-back the Adult Video News, Adult Entertainment Expo in Las Vegas, and then right after that, the XBiz 360 event in Los Angeles, it was just it was so striking that everyone was agreeing that policy issues are going to play a much bigger role than technology, any kind of technology issues, over the next few years in the adult industry. And the adult industry, the discussions I heard, the adult industry people, I thought I was at a media policy conference at both of these. the adult industry takes net neutrality and media consolidation issues, as seriously as the non-adult producers and consumers.
Well, the cutting edge.
And I think, what's really interesting, and I think the story that was in the speech right before this about how Prime Minister Cameron thought LOL means lots of love. Those are the people determining your internet policy. There's a real fear. I think that there's a natural tendency of our government wanting to control us. The internet is the Wild West. And I think that there's a fear that they're not going to be able to control that. So you're seeing these regulations come out. They're also talking, they're also getting the payment processors or the payment companies, the credit card companies.
Pornography has a tendency to just contaminate anything it touches.
Yeah, damn right.
I mean, even the association is enough to make people get scared that whatever else they're selling is going to be contaminated. But your excellent point about the history of dial-up porn, which made so much money for the phone company, that still happens today with the hotel industry.
That's right.
Yeah.
That's right.
Which makes millions of dollars off of adult films in hotel rooms, but is always extremely cautious to talk about it. The same discretion they give to their guests is the same discretion they like to have about the content, that they even have the content in the rooms. And the companies that own the systems in hotel rooms are varied and numerous and would surprise everyone, like the list of the people who own those actual pieces of hardware. So I think that's an excellent point that, these shadow regulations are one thing, but there's also a lot of shadow behavior by companies that are making this money too.
Mm-hmm. Can I go back to, because I'm surprised you didn't make the point about 2257 in connection with the Hollywood adult divide. In 2257A, they passed a law, okay? Hollywood, especially if you watch late night Cinemax or something like that, you're going to see people apparently having sex, and guess what? Some of them actually are. They just don't show it. But the point being, though, is that those movies, the makers of those movies, they don't have to keep the identification records, and they don't have to have a custodian of records available for 20 hours a week. All they have to do is write a letter to the Attorney General that says, why, yes, as a mainstream company, we keep tax records on our employees and things like that, and so we know who they are. We know they're not kids, so we don't have to keep all these records, and we don't have to label our content, to say, well, this is, this, to prove that this doesn't have kids in it, here's our custodian of records, and this is where he keeps those records. But adult companies, which, believe me, are not making child pornography because guess what? It's illegal. And they know it's illegal, but we still have to certify, we still have to keep the copy of the driver's license or the passport or whatever it is, and all the records. But an adult company cannot just send a letter to the Attorney General and say, we keep employment records and tax records and things like that, just like the mainstream Hollywood people do. Why can't we file a letter? We can't file a letter.
Unfortunately, being an adult film industry historian is rather depressing because these stories, as everyone up here knows, are mammoth and they're sad, but two things come to mind when you say that. First is that these shadow policies and regulations, it should be said again that they are systematic and they are designed to eradicate this industry. An example that Jeffrey hinted at was that in the mid-'80s, there was a federal strategy to prosecute obscenity in multiple jurisdictions simultaneously for the express purpose of bankrupting the companies. That was the whole purpose, was to bankrupt them or to level the threat of bankruptcy so that they could not defend themselves. And aside from Adam and Eve, which was mentioned, I think, by Mark, which had the resources to fight and, of course, proved successful, many companies went out of business. So, to answer your question, I think that the primary lesson is that these systems and regulations and policies will always recur. They're like mushrooms. They just sprout back up again, and they always come back with the same rhetoric and in the same ways and with very similar language. And so But one last comment is that something Des said today struck me as interesting, which was that it's messy. Democracy is messy, and sometimes the various voices need to be heard. And so user reporting on Facebook, for example, which is how these problems get reported, a single user can report something and affect a billion other people on Facebook. But that's not new. A single person could make a report about a drive-in in 1964. In the case I'm studying right now in Michigan, that exact scenario happened, and that drive-in there was an injunction filed, and the drive-in went out of business, and the person lost their livelihood based on one citizen complaint. So it's not new. So I think, to sum it up, sort of, it's just to be cognizant. Like these companies in Los Angeles and elsewhere, they already are, but they'll need to continue to be.
Well, right now, AIDS Healthcare Foundation, which is the entity that brought Measure B forward, is making ongoing complaints. They sit down and they watch video, and they've made complaint after complaint after complaint against companies. The employees with Cal OSHA, the employees and the performers, independent contractors in the videos are not making these complaints. And so numerous studios have been visited by Cal OSHA, and you walk in, Cal OSHA walks in, it's going to be something. And I had a meeting in Cal OSHA's office, and I'm going to tell you, I wish I'd taken my camera because it was a pigsty, and we could have found tons. But numerous, and so I'm finding people now going out of business because Cal OSHA has come in. There's never been a death on an adult scene. People are dying in California, in a lot of the different areas, and on a lot of different other industries. Nobody. I mean, our employees are not making complaints, but California resources, Cal OSHA resources, are now focused on the adult production. When again, this is not an entity, as Constance was saying earlier. And so it's really frustrating because you've got an entity that's kind of focusing and using government regulation and government organizations to take down an industry, and that is clearly the goal.
So this is tragic that we have to end here, but we do promise you that we will find a way to continue all of these discussions. Let's thank our guest on the Obscenity and Indecency panel.